Okay, we're going to get started. I'm going to introduce our speakers tonight and we'll get to the programming. So first, I want to introduce you to PMC and what we do. PMC, Pennsylvanians for Modern Courts, is a nonpartisan nonprofit that envisions a Pennsylvania judicial system in which everyone is assured impartiality, accessibility, and respect. We work to educate all Pennsylvanians about the courts and how to navigate them with confidence, especially tonight. We are not offering legal advice tonight, but we hope the program is informative and we will have time for questions at the end. Our speakers are Judge Elliot Howsie and Brian Catanzarite. Judge Howsie is a Wilkinsburg native and Duquesne Law graduate. He was appointed as Allegheny County's first African-American chief public defender in 2012 and sworn in as a judge in the Court of Common Pleas in 2019. Brian Catanzarite, also a Duquesne Law graduate, unclear what hometown though, is a trial lawyer and an active member of the Allegheny County Bar Association, where he currently chairs the Judiciary Committee. For 18 years, he worked in the office of the District Attorney of Allegheny County. So we'll be sending these slides around if you registered. If you didn't, just give me your email address and we'll get them to you. There's a lot on our website about what we do, including this information. Here are some upcoming events. But the main event is our presentation. So we'll hand it over to the judge and Brian. Okay.
All right, thank you, Nina. Nina said I'm Brian Catanzarite. I was a prosecutor for over 17 years here in Allegheny County. Judge Howsie, very experienced in criminal law as well, so I think you're going to hear a lot of really good points from him, and I'm excited to hear them myself. All right, so just to see, just for bearing, okay. All right, so we're going to talk a lot about just the criminal process tonight, the investigation and arrest, magisterial district court, here's preliminary arraignments, preliminary hearings, and then the next step of the process is Allegheny County Common Pleas, and we'll talk about the processes that are handled there. All right, investigation and arrest. So this slide demonstrates the kind of the basis of the courts. At the bottom there you have the magisterial district courts. That's the first step in the court process. They can handle civil matters. But as far as the criminal process goes, that's where your first hearings start, is in the magisterial district courts. The next step, if you get past magisterial district courts, you go to the common pleas courts, and that's where your criminal trials are conducted, the things you are used to seeing on TV. Superior Court handles appeals from the common pleas court. Commonwealth Court doesn't really interact too much with criminal. And the Supreme Court is at the very top. If they choose to hear an appeal that was already decided by the Superior Court, it would go to the Supreme Court. Any death penalty case is automatically reviewed by the Supreme Court. So just talking a little bit about how criminal prosecutions are initiated. And Judge, if you have something to add, you just shove me out of the way and take the microphone. So how criminal prosecutions are initiated: somebody calls the police, they're conducting an investigation into whatever crime you can think of, and there's two ways that someone can be arrested. Traditional arrest, where the police handcuff the person within their rights, take them off to jail. That's done with felonies, some misdemeanors, particularly with DUI, or when the police can't identify the individual, either they refuse to provide identification, or for whatever reason they can't get a firm identity of the individual, they'll be taken to the jail for identification. Or if they believe that there's good reason to believe that the person would not show up for a court appearance. Otherwise, criminal prosecutions can be initiated by service of summons. So you get served summons by either the sheriff or by certified mail. They let you know what crimes you've been charged with and your first court date at the magisterial district court. I'm hitting this arrow right there. Judge informed me he's never done a PowerPoint before, so this is we're learning on the fly. So there are, crimes have different gradings throughout the country, but primarily in Pennsylvania. Essentially 4 different classifications of criminal offenses. Homicide, which is fairly explanatory. Felony is the next level below homicide. It's firearms, aggravated assaults, robberies, some vehicle theft offenses. It's essentially any crime in which the individual can be fined over $15,000 and or sentenced to a prison sentence lasting longer than 5 years. So the next level down is a misdemeanor. Felonies and misdemeanors also have their own classifications. So there's felony of the first degree, which is the highest felony, second, third. Misdemeanor, same thing. Misdemeanor of the first degree is the highest misdemeanor, second degree, then third. And then below misdemeanor of the third degree is a summary offense. So that's maximum penalty for a summary is 90 days in jail or $300 fines. Typically your disorderly conduct, public intoxication, underage drinking, shoplifting, some criminal mischief, some trespasses are summary offenses. Harassment can be a summary or a misdemeanor depending on the severity of it. Each crime also sometimes has its own different classifications within it. So it depends on the activity that makes up that criminal mischief or the harassment, and so on and so forth. So like a misdemeanor, simple assault, it has some of the same elements of harassment, because harassment also includes striking another person, but depending on what you're striking them with and the severity of the injury to the victim sometimes makes up satisfies the element for harassment versus simple assault. Okay, criminal procedure for misdemeanor and felony offenses. So after there's the investigation and the arrest, the individual who's arrested goes before a judge for a preliminary arraignment. This is especially true when you're brought in handcuffs. You're taken before a judge before just being lodged in the jail. And that magisterial district judge who's presiding over preliminary arraignments determines whether a bond is set, the amount of that bond, and whether or not that person just goes to jail without bond. At that time, the defendant also receives a paper copy of the criminal complaint. And essentially what the judge is determining at that hearing, it's just whether or not that person will show up to court. And if there's a bond that they can put in place to ensure that they do. After that, the defendant will get a date for what's called a preliminary hearing. So this is the first step in the trial process. This is where they can have an attorney and the facts of the case are now at issue. So preliminary hearing is essentially a hearing just on, instead of a prosecutor trying to prove their case beyond a reasonable doubt, they just have to prove it to what's called a prima facie level. It's, was a crime committed? Did this person commit it? Do we have enough evidence to support that moving forward? That's all that's being done at the preliminary hearing. It's just essentially establishing whether or not there is enough probable cause that this is the individual who committed this particular crime. It is an opportunity for defense to cross-examine some witnesses, and it is the first time that evidence is presented for the crime. Once it's only done in front of the magisterial district judge, they're the only finder of fact at that point. There's no jury at that hearing. It's just one judge hearing the case. That judge decides that there's enough evidence to hold the charges over for court. Then we move on to the trial phase. Trial is when we're talking about, you know, what you're used to seeing on TV. You could have a jury depending on potential penalty, or you could choose to waive your right to a jury trial and proceed just to a non-jury trial where the judge sits as the finder of fact. Or you can enter a guilty plea and avoid that whole mess. Okay, so custodial arrest, that's the one we were talking about, again, where officers place you in handcuffs, back of the car, and read you your Miranda rights. And I think we all know them by now, but it's, you know, you have the right to remain silent. Anything you say can and will be used against you in court. You have the right to an attorney. If you cannot afford an attorney, one can be appointed to you. Depending on where the arrest takes place, the police have, I mean, they will search your person. It's called a search incident to arrest. Essentially, just making sure you don't have any weapons or dangerous substances on you. And they can do a wingspan safety search as well. So if you're in a car being arrested, they can check that car to make sure that there are no weapons within arm's reach. If they have to tow the car, they're going to inventory the vehicle to make sure that whatever's in there when the tow truck comes is in there when you pick it up as well. Yes, sir. For some things, yes. Yeah. So it's the law has even changed in recent years with respect to vehicle searches. So, you know, typically, if they're going to search beyond where there is a possibility for the individual being arrested to reach for a weapon, or where their safety is no longer in consideration, they're supposed to obtain a search warrant to search anything in that vehicle. Right. Now you've given them consent.
So because of
Like, where did it?
Cromwell versus Alexander, Supreme Court case, Pennsylvania, what it held was that prior to that holding in that case, officers could search your car as long as they had probable cause. Specific articulable facts that suggest criminal activity. They had a basis to believe that criminal activity was occurring. They had the ability to search your car, with or without your consent. Because of Commonwealth v. Alexander, now police need one of a few things to search a car. They need your consent. If they don't have your consent, they need a search warrant. They don't have your search warrant. They need probable cause and exigent circumstances. So what that means is there needs to be some emergency along with evidence that a crime has been. They don't have probable cause and exigent circumstances. They can't search without a warrant or your consent. All right, so that's been the change in the law. But people think that because they don't consent to a certain officer, they can't still search the car. There's still ways an officer to search the car, but if you consent, you do waive your right to contest the nature of that search at a later point. Right. So it can suppress their court. If he doesn't consent, there's no probable cause. Again, now you need probable cause and exit. It's not enough to just have probable cause. So if you think about marijuana, because people can smoke medical marijuana in the past, before it was legal to smoke medical marijuana, the odor of marijuana was evidence of criminal activity, reasonable suspicion. So if you smell marijuana, you could get a person out of the car, you could detain them, investigate further. Now the odor of marijuana is not evidence of criminal activity because one can lawfully possess marijuana. Oh, it doesn't trump federal law. Girl got arrested for why? Because she had a warrant every year off. But if you look at the state, the federal government faces state justice. Federal law. Well, that would have to be on in federal territory. Like federal gangland or a federal entity like DC, yes, federal law trumps state law, but it doesn't trump state law because most of our highways are contained within a state. In Pennsylvania, the odor of marijuana is not evidence of a crime. However, if you're, and this is a misconception, if you're driving with marijuana in your system, that is a DUI. And so a lot of people will have marijuana, they think I have a medical marijuana card. It is a crime to drive with a controlled substance in your system. And so it's still a DUI, even if you have medical marijuana card. But as Mr. Catanzarite was talking about with custodial arrest, as another misconception, people think the minute that they're arrested, they're entitled to their Miranda rights. They're entitled to be told you have the right to remain silent on anything you say or do. You can't afford an attorney on your behalf free of charge. Those rights are not implicated unless you are in custody and being interrogated. If you're not in custody and being interrogated, you're not entitled to Miranda. So it has to be custody plus question. If you're being questioned in McDonald, you're not entitled to Miranda. If you're in custody, not being questioned, not entitled to Miranda. Custody and interrogation, yes, sir. So detaining a person just means that you are impeding their ability. To detain a person, you need reasonable suspicion. To arrest or search, you need probable cause, the higher person.
You're doing pretty great. Yeah.
That's enough. That's not a crime because it's not a crime to have marijuana in your system. It's a crime to possess marijuana. It's a crime to possess cocaine. It's not a crime to have ingested it. So no, there's no crime. All right. So let's keep going. Can we keep going?
Sure.
All right. So you have a right to an attorney. You have a right to an attorney whenever you're being arrested. You have a right to an attorney whenever you're being questioned. And the only way that you can make an informed decision regarding waiving those rights is if you first been apprised of those rights. So you have to be told you have all of these rights before you can make a voluntary decision to waive those rights. But you have a right to counsel at every stage of the proceeding where there's a potential loss of liberty. You also have a right to not speak to attorneys because they're in privilege. You don't have to make statements to go incriminate yourself. So you don't have to give a statement to officers if you choose not to. But you have a right to an attorney if you're being questioned. You have a right to an attorney at a preliminary hearing. You have a right to an attorney at all stages of the proceeding except preliminary arraignment. When bail is being set, you're not entitled to an attorney. Although I don't agree with that, you're not entitled to have an attorney when bail is being set. So that at that stage, you're not entitled to an attorney. All other stages, you are entitled to an attorney. And so, and that's kind of how the public defender's office came into being because of the fact that it was Gideon versus Wainwright. He was being prosecuted for a crime and he wasn't given an opportunity to have an attorney because before the United States Supreme Court said whenever you are facing a deprivation of liberty, you are entitled to counsel. So you do have a right to counsel except for at the preliminary hearing. Any questions regarding what we discussed so far? If I can piggyback off of something Mr. Catanzarite said. He said that, and it's true, some police departments will arrest you for felonies and serious crimes. They'll take you into custody, you have to have bail set. Other offenses like a DUI or a simple assault, low-level misdemeanor, they will not arrest you. But in the city of Pittsburgh, so they have the ability to arrest you, take you into custody, or issue a summons and have you report by court order at a subsequent date for your hearing. Which place do you think issues the most summons? Which places do the most arrests? What do you think? In Allegheny County. Our boroughs and municipalities are more likely to initiate the process by way of summons because they don't have the manpower to take people to jail and still patrol the streets and do those things. The city will use arrest more so than summons. Why do you think that is? Why do you think that is? That's his old boss. My old boss. The reason why they do more arrests in the city, which is something that was kind of astonishing for me. I thought there were a number of other reasons, but the main reason why they are more likely to use arrest as a way of initiating the process in the city is because people in the city are less likely to have IDs. And if you don't have identification, we can't issue you a summons. So therefore, I have to arrest you and then investigate and get your information. You have to go before the district judge, have bail set, then you'll deal with your case as a progressive system. Municipalities are more likely to use a summons. And so, yes, sir. Okay, so it's almost like they walk down the street, doesn't have any not a crime. Second, ID, but that's not what I said. That's what you said. Right, right. Well, they can't even question you unless they have reasonable suspicion. However, if you do, or if you're allegedly involved with criminal activity and they cannot identify you, they have to arrest you. Bail has to be set. If you have ID, they have the discretion, but assuming they'll exercise that discretion fairly, they have the discretion to issue you a summons with a court order, come to court at a later date to deal with your case. So when we talk about bail, when we talk about preliminary arraignments, here's the thing, our pretrial services will make a bail recommendation on every person that is arrested in Allegheny County charged with a crime. They'll make a bail recommendation, not with summons because you're not being arrested. And the fun fact is that there's never a monetary condition of bail ever recommended. So there's never a recommended 5,000 or 10% or 100,000 straight. It's always in because you're unlikely to appear for a subsequent hearing, or because you're a danger to the community. We're not letting you go. Or we're releasing you with some conditions, but you're released without money. So it's not the pretrial that's making bail recommendations based on money. That's never a condition. It's been determined that monetary conditions of bail are discriminatory. They don't make us any safer. They don't increase the likelihood of someone to show up for court. And so that's just something I want to throw out there. But there are no bail recommendations containing a condition of money that are being made. Sometimes our judges will, as they say, freestyle and say, I feel better if I give you a condition of bail with 5,000 or 10% just to keep you honest. But there's no recommendation regarding money. It's always in because you're a danger to the community or unlikely to show up, or you're out with some conditions, report in person, drug and alcohol treatment, mental health evaluation, things of that. So any other questions? The gentleman here had a question. Yes, sir.
During the preliminary arraignment stage and having no access to both offenders at that point, what regards to behavioral competency evaluation, that person is in custody, then has to be placed under evaluation if they are.
Right.
Would the advocate or
You're talking about an involuntary commitment or a mental health competency evaluation? Your mental health involuntary commitment, yes, deprivation of liberty, you're entitled to an attorney. But if we're talking about preliminary arraignment, been held that you're not entitled to the attorney. However, some fantastic public defender who used to work there as a director, their name will be, well, we won't say their name, we don't have to. But they thought it was a good idea for attorneys to be present at preliminary arraignment, because even though you're not entitled to an attorney, that's the most crucial stage of the process. Because if you're in jail, now you're fighting uphill to get out, versus if you're already out, your case is taking a posture that you're more likely to not end up in jail as a result of the case. So as a result, the public defender's office now staffs preliminary arraignment, but they're not obligated to do it. All right, you want us to keep going, or you want me to? No problem. So you want to go? Let me keep going.
Keep going.
Keep going.
Yeah.
Keep going. All right,
Go for
so the magisterial district courts, their city court, which is downtown on 2nd Avenue, they deal with every crime that is allegedly, that occurs in the city of Pittsburgh. But then you have your boroughs and your municipalities. I think there's 46. There are 46 municipalities outside of the city. There are more than 66 in the entire county.
Yeah.
So there are 46 that have their own district judges. Ben Hills, Monroeville, North Purcell, Forest Hills, Braddock, they all have their own district judge. And district judges have the legal authority that they don't do trials because they're not a judge of the Court of Common Pleas. They're district judges. They can hear preliminary hearing. They can do preliminary arraignment to determine what bail conditions should exist. They can preside over any summary offense and any civil suit less than
$12,000.
So landlord tenant, small claims, district judges can hear those cases. Otherwise, if it's a criminal matter, they're not making determinations regarding guilt or innocence. You can't present a defense at a prelim. You're only determining does the evidence rise to a level that would suggest that a crime was committed and the accused is more likely to have committed the crime. The answer to that and those questions are yes. Case moves to the next stage of the proceeding, which is before a judge in the Court of Common Pleas. But the case can also be resolved with summary offense, which the court can say, hey, taking jurisdiction, we're going to find you guilty of disorderly conduct. summary harassment, and they can decide those. They can also preside over traffic violations. Those are summary offenses. They can't preside over a trial. Philadelphia, district judges can. Allegheny County, they cannot. Only summaries, landlord tenant, small claims, preliminary arraignments, and preliminary hearings. Agreed?
Correct.
All right.
Good job.
I'll
jump in. Oh, you already covered. Look at you. Yeah, we pretty much covered that. The preliminary arraignment typically takes place within 48 hours of their arrest. Allegheny County is very good at 16.
It's like less than 16 hours. You'll be arraigned at Allegheny County.
Yeah. Judge and I served on the Pennsylvania Supreme Court Rules Committee for Criminal Procedure. And what struck me the most on that committee was learning how different counties throughout the Commonwealth process people through their jails and through this system. And I mean, Allegheny County is very efficient. I mean, we have the resources to do it, and we put them to good use. Preliminary arraignments are held at Pittsburgh Municipal Court, which is located right next to the jail. Judge covered that. Preliminary hearings, essentially covered all of that as well. One thing about the preliminary hearings is they're not a court of magistrates. Magisterial district courts are not what we call a court of record. So there's typically not a court reporter in the room making a transcript. Pittsburgh Municipal Court does make recordings of their hearings. They're the official recordings. Nobody else is supposed to be recording those hearings. But they do have a transcript can be made from preliminary hearings at municipal court. And when homicides are heard, all homicide preliminary hearings, regardless of where the homicide takes place, those are all in Pittsburgh Municipal Court. It's a safety issue. So instead of taking someone from the jail who's accused of homicide and driving them out to Penn Hills for a preliminary hearing in front of that magistrate, instead, all homicide preliminary hearings take place in Pittsburgh Municipal Court. And at those proceedings, there is a actual court reporter in the room making a record for that as well. But typically at the magisterial district courts throughout the county, there's no transcript being made of those hearings. Yes, you can, but
the motion just requires money. You have to pay.
Yeah, right.
To show up. You have to. You're entitled to have a recording of your transcript, but if you want a court reporter to do that, you have to pay them their appearance fee, and you'll have to pay them per page for the actual transcript. If you are represented by the Public Defender's Office or the Office of Conflict Counsel, the county will pay that. I don't know what you mean by that question. Oh, it's all saved in the computer and on their forget the name of the machine. But they're saved, and then so anyone could access it. So it doesn't disappear if someone's unavailable.
Right. But I was showing somewhere with that. Yeah, well, and that's the thing. Like you can't request just to come in and make your own recording. Okay. Well, there are, but you need a certified court reporter to make an official transcript that you can use later in other proceedings.
Dead now, no longer is retired. expired and is dead, we want to access a file. What happens in that case? It can go to any other court reporter instead.
No. So what would happen is if that person worked for an agency, coworker should have access to that machine. Not that you could get a court order and then a judge can order that another court reporter transcribe the information on that machine, but you have to pay for it.
You had a question in the back?
You can take that one.
No.
No, absolutely not. No. And so everyone in here wishes they could make more money. All of us want more money. We all wish we could make more money. Am I telling you that anyone's getting rich working at the public defender's office or at the district attorney's office? They're not. However, when you look at caseloads in the Allegheny County Public Defender's Office compared to national standards, they're lower. When you look at attorney to client ratio, lower. So now I take exception to that. And while I was there, we got our budget increased, I want to say probably close to 35, 40% increase over the time that I was there. So there was never a time when I couldn't fulfill a request for an expert witness. I couldn't fulfill a request for a transcript. There was never a time that we didn't have the necessary things that we needed to effectively represent our clients. Now, can the argument be made that everyone should have been paid more? Absolutely. Myself included as a director. But there were raises that were given out while I was there. Our budget increased by millions of dollars each year, and we were able to hire the people that we needed to do the cases. So is it a general rule nationwide that public defender's offices are underfunded? Yes. To suggest that people got inadequate representation in this county because of that, I don't agree. Okay. But here's the catch. They didn't get sued because they were underfunded. They got sued because they were violating people's constitutional rights to competent, effective legal representation. Whether or not you got paid, you still show them do your job. Those are two different questions. So when you talk about money, I take exception to that. When you talk about competent, legal, effective representation, yes, they've been sued for failing to provide that before I got. But it's not about the money. It's not about the money. That was kind of like a footnote, but it was never about the money. But that's not about. But again, it's not about the money. It's not effective representation. But when I was there, and I'm not here to do a brag book, but we had a 66% acquittal rate when I was there at the public defender's office, which meant that out of 100 cases, 95, 96 will be a plea, guilty plea.
Yeah.
The other 4%, we had a favorable verdict 66% of the time when we tried cases. The point still remains, I know everyone talks about money because that's what everyone's accustomed to hearing. It wasn't about the money. Those issues that you're discussing had nothing to do with money. It had more to do with people showing up and doing their job. Should they make more money? Yes. But have they been in a position where they don't have the resources to effectively represent their clients? I disagree. Okay. All right. The county, it's a county entity, so the county controls the funding. But if you do your research and you look at that budget has consistently increased by millions of dollars each year. And if you look at the number of attorneys that they have, now will they say we still need more attorneys? Okay, I have no argument with that. But when you talk about the caseloads here compared to the national standards, I disagree.
Okay. I'm not sure I follow that. Yeah.
What kind of issue would if you are taking into custody of other cases?
Do other cases. Okay. No.
All of the cases there's some kind of order
Judicial economy, if the cases are related, same fact, same transaction, maybe they'll be tried together. They won't necessarily be tried together. But you can file a motion to modify bond. If you're out on one one case or out on two cases, you get arrested on the third. Question is, will they modify?
Once the court, but the county actually has to be about two other actions within person's life on the criminal charges. So, yeah, I know.
Yeah, I'm not. Well, okay, yeah, and yeah, I'm not sure. But you know, again, we also can't give legal advice up here. So, all right. No, those don't really exist in criminal court.
They do not exist at all.
No.
So, sure, but they will transport you to those other jurisdictions.
Yep.
We do transportation orders every day. So when you talk about discovery, fun fact, there's no reciprocal discovery obligation. So while the Commonwealth has an obligation to give you all of the evidence, good or bad, that they intend to offer against you or that they have in their possession, they have an obligation to turn that over. Defense counsel only has to turn over, arguably, only has to turn over expert reports. If you intend to call an expert at trial, the Commonwealth is entitled to that report and alibi witnesses. If you plan to present an alibi, you have to turn over that information. Other than that, defense counsel has no obligation to turn over the things that it has, but the Commonwealth has an obligation to turn over everything that it has.
Correct.
Well, no, it's all formal, but the question is, are you asking for it informally? And if they don't give it to you, then you'll make a formal motion for discovery.
Right.
So we have a good working relationship here with the defense bar and the DA's office, where you can just say, hey, here's the paper, give me my stuff. And most of the time you'll get it. If you don't get it, then you can file a formal motion for discovery and ask for sanctions.
And that means the formal motion means like it's filed with the court, and then the attorneys, the prosecutor and defense attorney, appear before the judge and have the judge resolve whether or not discovery's been turned over, what consequences there are if they determine that it was intentionally withheld or recklessly withheld. So that's the difference between formal and informal. Prosecutors are under the obligation that exists regardless of whether there's a formal motion. We just require the defense bar to fill out the paperwork so we know where the discovery is going, who the attorney is. That's about it. No. An injunction does not. There is no injunction in criminal court.
Were you getting an injunction is a court order restricting someone from doing something. You can't ask a judge to issue a court order restricting the court from doing something. So there are no injunctions in criminal court. You can get an injunction against your neighbor for driving through your yard. You can't get an injunction in criminal court. Yeah. But you can't. And here's the reason why. Because if you're arrested in Westmoreland County for a separate transaction, Butler County for a separate transaction, there's a thing called jurisdiction. That crime can't be brought to Allegheny County and prosecuted because it didn't occur. So you may think it's in your person's best interest to have all those cases resolved together. One, legally you can't, and two, it may not be in their best interest to have all the cases resolved at one time. You're welcome.
So then there's after the preliminary hearing, then there's a formal arraignment where district attorney's office files the official criminal information. That it's the charging document that contains the final charges that made it through the preliminary hearing. The defendant is provided with a copy of that document. Judge is assigned at that time, and the discovery request comes in. That's also the period where the defendant may file their pretrial motions to suppress if there is an illegal search. A habeas to essentially say that there is no evidence to support this crime. Change of venue, motion in limine to keep certain evidence out. At the pretrial conference, defendant and or counsel selects a trial or guilty plea date with the assistant DA in the court. So the pretrial conference in some jurisdictions, that's like a scheduling conference where they discuss the case with the judge and try to figure out whether it's going to be on the trial calendar, how much discovery is needed done. In Allegheny County, it's essentially a scheduling date where defense and the DA just pick a date with the court, and the defense listed either as a trial or a plea. A lot of things get listed as trial because the defense attorneys don't have all of the discovery yet, haven't talked to their client yet about the case with the discovery, then they don't know whether it's going to be a trial or a plea. And it's always easier to turn a trial into a plea than a plea into a trial. So, and then as we wait and approach our trial date, you'll have hearings on the pretrial motions, and that's when discovery is exchanged as well.
What is Rule 600?
A dumb rule. So Rule 600 is it's the speedy trial rule. It says that the Commonwealth has 365 days to bring you to trial on your charges, and 180 days to bring you to trial on charges if you're incarcerated. It's not a dumb rule. It's just it is one that just keeps the pressure on when you're still processing certain trials.
What happens if a person is in jail and they've exceeded 180 days?
That person can be released on nominal bond.
And if it's the 365th day and they've exceeded, the Commonwealth has exceeded that time period, what happens?
Charges get dismissed. Yeah.
Minus any continuances by defense counsel.
Yes.
Defense counsel continuances stops the clock. So if your defense attorney postpones the case for 90 days, you get 90 days added on to the year. Okay, but otherwise, the Commonwealth has 180 days if you're in jail, 365 if you're out. Here's the catch. On the 6-month rule, if you're in jail, arguably you're entitled to nominal bond unless the charges are of such a nature that you're not entitled to bail, like first-degree murder or some type of serious homicide, or if a judge makes a determination that you are a danger to the community, then you still will not be released even though you've been detained longer than 6 months. Yes, sir. It could happen, but there's more to that story than that. But go ahead.
Yeah, I mean, I'm not saying basically like state court.
So if I may, people are typically in jail because of one of 3 or 4 reasons. Serious offenses, homicides, rapes, robberies. You're probably not someone who should be bailable because of the nature of the offense. There's an argument that can be made that you're a danger to the community. So you're more likely to be in jail pending trial for a serious offense. If you're on probation and you violated a condition of your probation with a new arrest and your behavior is escalating, there's an argument to be made that you should be detained because of your probation violation until you resolve that case. Then you deal with the probation violation. So, contrary to popular opinion, it is kind of tough to really end up in Allegheny County Jail unless you are charged with a very serious offense. Because if you think about it, and I can't remember the stats, but I want to say 50% of the people in the Allegheny County Jail are there because of probation violations. So if you think about the other 50, I'd probably say 25 to 30% of those people are there for serious offenses. The vast majority are there for violations of probation. And so when you talk about sentencing, the vast majority of the people who end up resolving their cases for nonviolent offenses, low-level offenses, they typically are going to get probation. So it's counterintuitive to put people in jail, then wait to give them probation to get them out of jail. So go ahead. Well, I don't work at the jail. I mean, so let me push back because I was on the jail board and that was a frequent question. So does the jail need to do better? Do the courts need to do better? Everybody should be doing better in our criminal justice system, the jail included. But if you think about who's in jail? Absolutely. Poor people are in our system. Who else? high-risk behavior, alcoholics, drug addiction, right? So polysubstance abusers. So when you look, and then people who also aren't really necessarily inclined a lot of times to be very proactive with addressing their health issues. I'm not saying that's okay, but what I'm saying is you're dealing with a population who is prone to having a lot of health issues. No one should go to jail with that. I'm not suggesting that it's okay or this is why it's happening. I'm just saying there are people in jail with a lot of very serious health issues. Mental health as well. Mental health as well. But no one, I want to be clear, no one should go to jail and lose their life. But a lot of times when people are dying in the jails because of pre-existing conditions, it's not always because of poor treatment. I'm not saying that hasn't happened. I'm saying the majority of the time it's someone who has snuck drugs in the jail when they were arrested and they overdosed. Someone who had drugs in the system when they arrived at jail and then they overdosed in the intake department. There's a lot more that goes on to that. I'm not saying there weren't mistakes that haven't been made because they have. But I'm just telling you, you're still dealing with a population that is a high risk population. Oh no, there are more people in jail than there are people on house arrest. Because a district judge sets bail, a district judge cannot lawfully impose a condition pre-trial detention via electronic home monitoring. So district judges have to say in or out, and occasionally put a little money on that too. But
whole different pottery of conflicts as opposed to sitting in jail.
So what are you saying, jail will be better? I don't understand. Well, for some people it would be, because some people, if you let them out, they're going to overdose and die. Sometimes you're just putting people in jail to save them from themselves. But I don't subscribe to the notion that we should put people in jail to help them. Jail is not about helping people. So I don't agree with that a little bit.
Okay, so why are so many guilty pleas entered in criminal cases? According to the Unified System of Justice of Pennsylvania website, 66.9% of Allegheny County defendants pled guilty in 2019. In 2020, that was 63. That's got to be high. Oh, yeah. I was going to say, that's low. Yeah.
So why do people plead guilty?
Generally because they're guilty.
Spoken like a prosecutor. So people plead guilty sometimes because it's mitigating your exposure, right? Minimizing your risk. If I plead guilty, I'll get this, versus if I go to trial and lose, I may get this. Sometimes it's about, I did it. Sometimes it's about, I may not be guilty of selling the drugs, but I am guilty of possessing the drugs. So I'll plead to the misdemeanor if you withdraw the felony. But our court system cannot function if everyone that's charged with a crime elected to have a trial. There's no way we can manage all cases. So, got you. So people will request, will plead guilty. Sometimes I'm not concerned with this case. I'm more concerned with my probation violation or my hold from another county. So a lot of times people plead guilty is strategic. Sometimes they're guilty. And sometimes it's about risk management. So, so just know that everyone who is arrested for charged with a crime, not necessarily, he would say they are, is not necessarily guilty of their charges. Again, you may be guilty of driving the car, but you're not guilty of the DUI. You may be guilty of having drugs, but you weren't selling. So it just depends. Yes,
well,
there were certain people that had maybe they didn't understand what was going on. I'm not even coping like that.
Sure.
Pretty much get liberty.
Sure.
So what do you do with people like that? Pretty much the education and whatever.
So all you can do as a judge is take them at their word. Slow the pace down and say, hey, look, do you understand the rights that you're giving up? You have a right to a jury trial. You have a right to call witnesses, participate in the process of selecting jurors. Or are you inclined to plead guilty? Do you understand what that means? That's all. And if they say yes, how can I challenge that?
Not only that, Judge, if you don't mind, but like they are represented generally by counsel as well. And so if the attorneys are like, this guy's not getting it, they can file, they have an obligation to have that individual evaluated by a professional to determine whether or not they have the ability and the capacity to understand. Because, I mean, there are a lot of steps. You just don't just say, I'm going to plead guilty and the judge sentences you. There is a long plea colloquy that the judge goes through that asks all the questions. Do you understand? Reads the charges, reads the potential maximum penalties, Do you understand what you're being charged with? The consequences for it? Were you on probation at the time? What the consequence of that could be? Do you understand? Are you entering this plea knowingly, intelligently, and voluntarily? They ask the attorney if they believe that that's the case as well. So that whole thing where I just went in and I didn't understand what was happening. I mean, there's a lot of steps between figuring out that plea and that plea being accepted by the court, because the court can reject that plea. I've had a number of times where defendants are up there and just decide at that point that, no, I am not entering this plea. You know, we had everything worked out, and then they walk away.
I'll push back a little bit, because I'm not going to sit here and tell you that there have not been times when people pled guilty and have no idea that this happened in court. It has happened. Should it happen? No.
No,
Because as
right.
a judge, you should take the time to make sure they understand. Your attorney should make sure they understand, because there are collateral consequences associated with conviction. They do need to be apprised of that before they plead guilty. And if they're not, then it's not a voluntary plea. You can't waive a right until you understand the rights that you're giving up. And so I'm not going to say that there haven't been times when I've seen people, as a defense attorney, when other people, represented by other attorneys, walking out of the room saying, "What just happened?" But that should never happen. That should never happen. That should never happen.
I honestly think that's where we see a lot of part of the systemic racism, or that they're calling it, or the systemic prejudice in regards to the not knowing and accepting.
What do you mean by that?
I honestly feel like some people really are pushed in the rest or accept.
I don't agree
And
with that.
for not knowing.
I don't agree with that, but I do.
And that's our.
Go ahead.
I think there are moments that we have to work that are suitable to their purpose and they are ordered. But there's some actions that we have to do.
Okay, so let me tell you this. If you do a statistical analysis of our court system and any other one in the country, there's a racial disparity every decision point. Does that mean that the judge in courtroom 3 is racist? No. But I do believe that the way that we bring people into the system and the way people are processed through the system, it has done what it's always done. And there's disparate treatment, in terms of our outcomes. However, I am an African American and I work in the system as well. So I don't think there are any judges that are intentionally in that courthouse, none of my colleagues in criminal court, that are saying, you know what, let's stick it to the Black and brown people, give the other people a pass. Now, it may be because of your limited resources that you can't afford an attorney who's on the same level as that attorney. There are a lot of variables that come into play. Sometimes because you may be arrested in the city, sometimes officers overcharge. So your starting point is worse in terms of arrest. There are a million variables that can impact the outcome of a case, but I can't deny that there is a racial disparity at every decision point. Of course, that's a true statement.
High school graduate with a AD, but I do think that there is some level of civil responsibility and citizenship that a high school student should graduate with, to understand being able and what is actually entailed in accepting the guilty plea.
Well, the catch with that is, yes, but the catch with that is that there's a direct relationship between people who end up in jail and people who drop out of school. So the vast majority of people in our court system did not graduate from school. And so, I hear you, but I don't know how you fix that. But again, the attorney and the client have an obligation to speak up. You have your hand raised. Yes, sir.
Yeah, I mean, I'm going to say that they're going to be very, have the first Black American being people on anything, all the race. Because he's being complained by African American first dealing with this media. Now, I don't know if it's true or not.
So what you're saying is, because the mayor said it has to be true?
No,
That is like
that's what I'm saying. I'm not saying it's true. I'm just saying studies that in America. Crazy people for Black man.
Sure. But let me just tell you this. I'm an African American judge. He's a prosecutor. This person may be a PO. This person may be an officer. This person may work for pretrial services. You understand how many hands are involved in this process. So is there an argument that could be made that the district attorney should take a different approach with some cases? Okay, you can make that argument. I got no issue with that. But to suggest that he and he alone is responsible for the outcomes in our court system, too many people, too many chefs in the kitchen to lay that at his feet alone. I got to own some of it. I'm a judge. I work in a criminal justice system. So we as a group have to do better. Now, I'm not giving him a pass, but I am saying I don't know that you can say he's the reason for all the problems in our system. Because we had a situation with a judge a few years ago that was problematic. So it's everyone needs to do that. Everyone. DA included. Everyone needs to do that.
I remember when we had where order is
Yeah.
really don't have that anymore.
Why not? Why don't we have that anymore?
Well, I mean, the order needs to be independent.
You know what? You remind me of my ex-wife. You know a little bit about a lot of things, and you just run with it. The reason why there was an argument, there was a fight. I can't deny that. The big fight. But understand that we were the only county in the state that was doing open inquest. No one else was doing it that way. Hey, I wasn't there either, but I'm just saying.
It was better when you did have an R.
Let's see, again, you're doing it again. Because what you're saying now is the DA controls it. Did you not hear him? The DA does not control it. The district judge listens to the evidence and makes a determination as to whether or not the Commonwealth has met its burden. So Stephen Zappala is not determining whether or not people get prosecuted for homicide. District judges are. So for you to say, look, I am not here advocating for anyone. I just want you to understand what you're saying. You understand? Let's get
All right. So we all pretty much know sure the stages of a criminal jury trial. Judge just had one today. So there's a selection of juries. If you get called to jury duty, you sit in the room with everybody, and the attorney sit up front, and the defendant is there as well, and they interview however many people they need to interview to get to roughly 14. So 12 people to sit on the jury and 2 alternates in case something happens with one of the jurors. Once that happens, you move on to begin your trial.
So you get 5 peremptory challenges for any reason you deem appropriate for misdemeanor charges, 7 for felonies. And jurors, where do you think jurors are picked from? Where do jurors come from? How do we assemble a panel of jurors? Based on what? Driver's licenses database, driver's license database, and voter registration database. So there's also an underrepresentation of minorities in the jury pool because that's where we get our jurors from. But that's where we get them from. 5 strikes, peremptory strikes, challenges for any reason you want for misdemeanors, 7 for felonies, and you have an unlimited number of challenges for cause. If a juror comes in and says, I cannot be fair and impartial in this case for any reason, you can do an unlimited number of challenges for cause and remove each person from the jury panel.
Thanks. No problem. Once you have your jury, you start your trial. Opening statements, typically in a criminal case, a prosecutor goes first for opening statements. They lay out their case. Defense goes next. And then the prosecution has to put on what's called its case in chief. That's your main case. You call witnesses. Prosecution does direct examination, so it's all open-ended questions, no leading questions. Defense then has an opportunity to cross-examine each witness. Those are pointed and leading questions. At the end of when prosecution's done putting on all of its evidence, they will rest. The defendant can then make a motion for judgment of acquittal. So if we're in a jury trial and I rest my case, the defense will ask to approach the judge, and they'll, outside of the earshot of the jury, make a motion for judgment of acquittal. That's saying that I didn't put on enough evidence to meet my burden of proof. The judge will generally deny that because I'm really good.
The burden's low.
Just kidding. It is low there. It's not beyond a reasonable doubt at that point. At that point, you're still at probable cause. Then the defense can put on a case if it wants to. And so the roles are kind of reversed. They ask the open-ended questions and I would cross-examine. And then when everybody's done, so long as there's no rebuttal, so if defense does put on a case and they raise something that I couldn't have addressed in my case in chief, I could open a rebuttal case. that doesn't happen as often. Once everybody's done presenting their cases, each side rests, we proceed to closing statements. And at this point, the defense goes first because the prosecution carries the burden of proof. So I'm the last one to address the jury before they get their instructions. So we give our closing statements, and then the judge reads jury instructions to the jurors. They are fully instructed on burden of proof, evidence issues, the elements of the crime, and how the jury is to deliberate. The jury is sent out for their deliberations. They pick a four-person, then they talk about the case and generally hold a vote and then deliberate back and forth about what they believe actually occurred. And then at the end of that, hopefully, they render a verdict.
That's the unanimous. Unanimous
Yes.
for not guilty, unanimous for guilty. If there's no unanimity, then it's a hung jury and the case can be tried again.
It can be tried again.
If they can't reach a unanimous verdict, whether it's guilty or not guilty, the case can be tried again. The record that I've seen since I've been around was six jury trials. A person was tried 6 times before the different juries could reach a verdict. He was ultimately found guilty. Cases don't typically get better for the defense with retrials because you have transcripts and you have sworn testimony and you can't change your testimony. Now the DA knows your theory of defense. But it usually doesn't get better the more times you try it. But you can be tried each time as long as there's no final resolution, guilty or not guilty. Yes, sir.
Yes, sir.
Well, the DA could always elect to withdraw charges.
Yeah.
But they don't have to just because the jury couldn't reach a verdict. They don't have to. Okay, here we go. Go ahead.
I was wondering, say like, okay, it's a murder charge. If you think the DA's taking DNA,
Okay.
you get the DA back, DNA back.
Well, no, your DNA is probably in that database. You haven't been convicted of a crime. But I think you once, it depends on the statute, and I don't know, but I would imagine if you've been charged with a crime, or you probably have to be convicted though. So if you're not convicted, your DNA probably shouldn't be in that database. Because it's a condition of your probation.
Right. Yeah.
That you have to show DNA. So it's as a result of a conviction. So arguably, if you were acquitted, you probably could get your DNA removed from that database. Another thing, expungements and pardons. I know it's probably not in here. People always want to say, I want to get an expungement. You can only get an expungement for offenses that do not result in a conviction. If you were charged with robbery, a gun charge, a simple assault, and you plead guilty to simple assault, the robbery was dismissed or withdrawn, robbery can be expunged. The gun charge can be expunged. Simple assault cannot because you were convicted. So anything that results in a conviction is not eligible for an expungement. Can't be removed from your record by way of expungement. Now, we do have some legislation, clean slate, low-level misdemeanor offenses, nonviolent crimes. They can be sealed from public view after 10 years, and you stay out of trouble and you pay your court costs. But expungements only for cases that do not result in a conviction. A governor's pardon is for any crime that resulted in a conviction. You can ask the Board of Pardons to pardon. That's 2-year wait. It used to be about 2 years, a little bit shorter now. It used to take 2 years. I do. You can take 2 years and you have to do an application, discuss your charges, discuss the outcome of the case, what your response was to the charges, and what have you changed now such that you should get a do-over. And they're granted all the time.
Well, now, if you were an active robber, he committed a racist crime, and the governor refused to perform it.
Who refused to do that?
It was the governor of Massachusetts, Auburn.
It's not just the governor. It's the Board of Pardons. The governor gets the vote, but it's the Board of Pardons. I think it's 3 out of 5 have to vote to give you a hearing, and there's a certain percentage that have to agree to pardon you. But I'm telling you, it happens all the time. So a conviction can be pardoned, acquittals, withdrawals, dismissals can be expunged.
I think the premise for that is that the reason why you're asking for the pardon is it has created such a financial barrier in your life.
Right. But it's incumbent upon you to put forth evidence to say, this is who I was and this is how I changed. And I've seen people go in and say, I didn't do it, it wasn't me, I was falsely convicted. You're not getting a pardon if you're not owning it. You have to own it and talk about what's new, what's changed, and how has this impacted. Yeah. But I still think it takes about 18 months. I don't think it used to be 2 years, so I don't, it's a pretty lengthy process because you have to give references and they have to do a background check. They have to vet your references.
All-time member.
There you go. So then I'm telling what I'm saying is true. What I'm saying is true. You're fact checking me.
So I think we're going to have to leave it there because we're over on time. But essentially, appeals can happen only on convictions. So you can appeal a conviction. We can't appeal a not guilty. So other than that, if there are any other questions, we'll take those.
And you can appeal